Welcome to Trust and Estate Clarity with Dada Law Office.
Welcome to Trust and Estate Clarity with Dada Law Office with attorney Codi Dada, founder of the Codi Dada Law Offices in Novato. Recognized as one of the top 10 best law firms in California, Codi focuses exclusively on estate planning, trust, and probate administration. I'm Lisa Mosbey, your host, and today we're looking at what happens to a home in California when it's not placed into a living trust and why that one detail can completely change what a family has to deal with after someone passes away. Thank you so much for joining me today, Codi.
Thank you, Lisa. It's nice to be here.
You know, Codi, how is a home handled after someone passes away in California if it hasn't been placed into a trust?
Well, if it hasn't been placed in a trust, then if the owner passes away, then no one else in the real world knows who's in charge of that property. So that means that we have to go to court, what's called probate court, and get someone authorized with the authority to manage that asset, to manage that property, and to be able to insure it and sell it and do anything that needs to occur with that property. And unfortunately, probate in California is a very expensive, time-consuming process that usually involves the involvement of, court and attorneys, right? So that's what we want to avoid.
I completely understand. Why does a property like that usually end up going through probate, even if there's a will in place?
Now, if you just have a will, that doesn't necessarily avoid probate. What a will does is it instructs the court how you want your assets to be distributed. A will has no legal effect in the real world unless you go to court first and get it acknowledged and go through a probate process and get what they call letters of administration or letters of testamentary, depending if there's a will or not. And that is a court order that gives the person that's requested the authority the legal ability to manage the assets of the decedent. So again, that requires going through this long, very expensive legal process called probate, which is what we want to avoid. That's why everyone should have a living trust in place and should have their home or all the real estate properly titled in their name as trustee of their trust.
And Codi, can you walk us through an example of how this situation unfolds for a family dealing with a home that wasn't in trust?
Great question. Right. So if the home isn't in trust, then before anyone can do anything, someone has to fill out what's called a petition for probate and file it with the court. And at the same time, they have to put a newspaper ad that gives notice to the world of the decedent's estate. At that point, it becomes a public information, and anyone wanting to know the heirs and the assets of this estate can easily look those up. But the process requires three major steps. The first step is to get appointed as the administrator and give notice to all the interested parties, put a newspaper ad, and file proof of service and proof of publication with the court. If everything's done correctly, the court will issue a court order called letters of testamentary or letters of administration. At that point, the person who has authority will be able to manage the assets of the estate, whether it's sell the real estate, insure it, whatever is going on at under the circumstances. Those letters, they call them, are what give the person the ability to manage the assets. Now, a trust is very different because a trust doesn't require court involvement. A trust is a legal entity that's recognized in the real world without court involvement. And had that property been placed in a trust, the people listed in the trust as the trustees would be able to easily step in with a simple showing of a doctor's note showing the person has become incapacitated or a death certificate. At that point, that person would have the legal authority to manage those assets and follow the instructions of the trust without the court having to supervise the process. which is a huge advantage because now we're not paying for the probate fees. We're not paying for filing fees. We don't have to put a newspaper ad, and we can avoid oftentimes attorney involvement, or minimize attorney involvement to where it becomes more of a coaching role than rather than, a full-on probate process that requires attorneys throughout every step. And then with that comes avoiding the statutory compensation, which is the way that the executors and the attorneys would get paid through probate, which is a percentage of the overall estate value.
And I know, Cody, it's very expensive to go through probate. But what does the process of transferring or selling that home through probate actually involve?
Well, after you get the court order, the letters of administration, after you filed the petition, put the newspaper ad, given notice, and filed proof of notice and proof of publication, then you have to do what's called a notice of proposed action. And all the interested parties have to receive a notice of what the executor is planning on doing. They have to tell them, we're going to sell this. This is the price we're going to sell it for. This is the sales commission and all the details of the sale. And then all the interested parties will have an opportunity to either object or consent. If they consent and everyone signs off, then the executor is free to do what they plan on doing. But if one of those people want to object or have questions, they could hold up the sale. They could, cause conflicts and slow things down for no good reason. So again, with the trust, that process is not required, whereas with probate court, it is required. Now, once that hurdle has been removed, then the executor can go ahead and hire a real estate agent and sell it. And once that property is sold, the money has to go into an estate account. So it can't be distributed. Even though the property's been sold, the funds from the property have to be put into this account, which is titled in the name of the executor, but as a personal representative. And so the money has to stay in that estate account until the final step of the probate process that requires the court to review all the actions of the executor and ultimately provide an order for distribution. It's only after the court issues the order for distribution can the funds be distributed to the beneficiaries. And again, very, very different than a trust, because a trust doesn't require the court to formally approve everything.
And I know with the court approving everything, Cody, there might be delays or complications. What kinds of delays or complications tend to come up specifically with real estate in probate?
Well, there's a number of possible delays, complications, but some of the more common ones are that there could be liens, there could be judgments against the property. Also, before the assets can be distributed, all the taxes have to be filed, all the bills have to be settled. Sometimes credit card companies will file a claim against the estate, because once your estate is in probate, it's much easier for credit card companies to file a claim against the estate. It's a very streamlined procedure for them. Whereas if it wasn't going through probate, then the credit card companies have to file a formal suit to obtain a judgment, which oftentimes is not feasible. If the credit card balances aren't huge, then oftentimes those credit card companies will just write it off, because the cost of collecting the outstanding balance may be more than what could be collected. Whereas through probate, it's very simple to make that claim. And once a credit card company or any creditor makes a claim through probate, the judge will not approve the distributions until we can show that those claims have been satisfied. So that's another big reason why these things get held up. Then you, right. Um, let's see. The other ideas that those are pretty much the same. I could go on, but there's several different things that could come up that hold it up. Conflicts between beneficiaries, people gaming the system, trying to make problems just to get a larger chunk of the proceeds.
And then, Cody, how does the court influence what can or can't be done with the property during that process?
The court follows a very stringent procedure. So it's very black and white. They want to make sure that number one, the property is sold on the open market so that there's no secret deals and that we know that the property is sold for the maximum amount, what the market will bear. So people can't make little side deals. And if you're going to buy the property from the estate, you have to get it appraised and you pay fair market value. And the court is there just to make sure that everything goes smoothly, but with it brings a lot of bureaucracy and a lot of delay.
So, what options do families typically have once they inherit a home that's tied up in probate?
The options, well, if they all agree to keep the home intact, then they can take title with all of them on title of the property. So multiple people can own the same property. But what happens is that usually one of them wants the money rather than the property. And if they all can't agree, or if the others can't buy out the person who wants the cash portion, then the court will prefer to sell the property. So again, they can force you to sell the property if everyone doesn't agree or if there's no way to compromise.
And are there situations where a home might avoid probate even if it isn't in a trust?
Even if it isn't in a trust, well, there's the joint tenancy, right? That means if you own property together with someone else and one person passes, that person's share automatically goes to the joint tenant, right? But that may not be what that person wants. Yes, it will temporarily delay probate. Well, if that property remains in one person's name and that person passes away, now we don't know who's in charge of that property. And so we have to go to court to get someone legally authorized, right, to manage that property. There's what's called a transfer on death deed, but those have many complications. I've dealt with those. And what that says is that when someone passes, this property transfers to this other person, but it doesn't give them authority in the meantime. So during the time that the property is still in the decedent's name, the beneficiary can't manage it. And it's a little bit of a process to transfer it into that person's name, and it exposes it to challenges by other people. Whereas in a trust, it spells out exactly what that person would want.
So, Cody, for someone who is setting up a plan right now, what should they be thinking about to make sure that their home doesn't create problems later?
So what's important to avoid all these hassles is that you place the title of your home into your name as trustee of your trust. That's what officially connects that asset to the instructions of the trust. And that's what tells the world that you would want the instructions of your trust to govern the asset that's titled into your name as trustee. And by doing that, we don't have to go through probate court. We don't have to get anyone authorized. We don't have to get a newspaper ad. We don't have to send out notices to, people that aren't interested or who aren't listed in the trust. And it makes things go much smoother. The instructions of the trust will say that if you're unable to manage your assets, then these are the people that would step in. Those are the people that you've selected to act as successor trustees. And at that point, they could seamlessly step into your shoes without having the court approve them. And so that avoids the whole probate process. A very simple procedure. Everything stays the same. There's no property tax increase. You can still sell the property. You can buy additional property. Whatever you normally could do, you could still do as a trustee of your trust. Literally everything stays the same. There's no special tax returns. There's no ongoing maintenance fees. But the fact that it's held in your name as trustee of your trust allows the rest of the world to honor the instructions of the trust without having to get legal authority through probate court. And that's what really avoids all the problems.
Excellent. Thank you so much for your insights today. I've appreciated this conversation.
Thank you, Lisa. My pleasure.
Thank you for joining us for the Trust and Estate Clarity with Dada Law Office with attorney Codi Dada. Please take a moment to subscribe, like, and share this episode with someone who needs to hear it today. For more resources or to start your own plan today, visit dadalaw.com. Thank you so much for tuning in, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.